If it pleases the court, my name is Murphy initial M, and I am here today with my learned junior, Hendricks initial J, for the defendant, True Tone Grill. Your Honour, the principle behind the tort of negligence is that compensation can be provided to those who have been mistreated, injured, or have had property damaged by the negligent or careless actions or omissions of another person. Only once a duty of care that can be established, a breach of that specific duty, and a direct causal link verified, can an action in negligence be upheld. Before this court, the plaintiff claims that the negligence by the defendant has directly resulted to his personal injury and consequential psychological injuries. The counsel for the defendant contests this claim on the basis of three submissions. Submission 1. The defendant does not owe a higher standard of care via the means of controlling rowdy or intoxicated persons from injuring other patrons. Submission 2. The defendant has not breached his duty of care on the basis that he failed to ensure that the assailants left the premises and that the plaintiff was safely escorted to his vehicle. Submission 3. The acts of third parties break the chain of causation and the risk of psychological injury was not reasonably foreseeable. I will provide submissions 1 and 2, while my learned junior will provide submissions 3. I will now begin with submission 1. The counsel for the defence does not refute the claim that there is a duty of care owed to the plaintiff. However, occupiers have a general duty of care to an entrant. This duty of care is limited. The counsel for the defence submits that the defendant did not owe a higher standard of care to the plaintiff on the foundation that the relationship between the parties did not extend the scope of duty. The plaintiff's submission suggests that the duty was owed in regard to taking reasonable measures to control rowdy and intoxicated patrons. Your Honour, as for the handling of rowdy and intoxicated patrons, from a licensee's point of view, the defence looks to Wagstaff against Haslam, a 2007 case from the New South Wales Court of Appeal. It was held that the mere fact of degree of intoxication will not give rise to a duty to take immediate steps to remove an affected person in order to protect other patrons. An additional element is required, namely knowledge, either actual or constructive, of the aggressive character of the person when intoxicated, based on either known characteristics or conduct on the occasion in question. This can be found at Chapter 50. Therefore, in the present, it is inconceivable that the defendant would have actual or constructive knowledge of the assailant's aggressive character prior to the attack, thus not verifying this crucial element. Your Honour, the defence submits that in accordance with the judgment found in Wagstaff and Haslam, the defendant acted well within his general duty of care owed to an entrant and not owing a higher standard of care, somewhat voiding the plaintiff's claims that the defendant incorrectly dealt with the eventual assailants. I will now proceed with submission 2, that the defendant has not breached the duty of care on the basis that he failed to ensure that the assailants had left the premises and that the plaintiff was safely escorted to his vehicle. Your Honour, in TAB Limited against Atlas, a 2004 case from the New South Wales Court of Appeal, Justice Ip, where Justice Beasley assented, quoted at Chapter 65, Mr. Youngman may have made an error in judgment in not telling the men to go and that he would call the police immediately. But I do not think that amounted to negligence in my view, a finding to that effect would be an impermissible finding of negligence by hindsight. Imperatively, in this case, the appellant's appeal was upheld, finding no liability for negligence. In contrast to the present, the defendant immediately removed the eventual assailants as soon as there was an altercation. Therefore, as the defendant exceeded what was expected by a licensee in comparison to TAB and Atlas, by removing the patrons off the property, it must be held, Your Honour, that the defendant did not breach the duty of care owed to the plaintiff. In response to the claim that the defendant breached the duty of care owed to the plaintiff through not ensuring that the plaintiff was safely escorted to his vehicle, the defence looks to Modbury Triangles Shopping Centre Proprietary Limited against Ansell, a case from the year 2000 from the Commonwealth Law Reports. Chief Justice Gleeson, Justices Gaudron, Hayne and Callanan held within the case that a licensee's duty as an occupier of the land did not extend to taking reasonable care to prevent physical injuries resulting from criminal behaviours of a third party. As such, it would not be reasonable in suggesting that the defendant had breached this duty in the present, as no such duty exists. Consequently, the defence submits, upon reliance of the judgments of Tab and Atlas and Modbury Triangle Shopping Centre, that the defendant has not breached a duty of care, as this duty does not exist outside the scope of the defendant's general duty of care owed to an entrant. My learned junior will now provide submission 3.